Yeah, that's the thing. So the other thing I've discovered in my experience here in probate real estate is the biggest misconception that I get probably weekly is I don't need to worry about a living trust. I have a will. So, and I try to describe, well, there's a piece of the will that goes in your living trust package, your estate planning package, but that a will is worthless until it's probated in court. Does that sound about right to you? Is that how, or how do you describe that process?
No, I like that. So is it worthless? No, I just tell people that a will does take legal effect when a person expires, but it offers no privileges, no protections prior to passing away.
But it also needs to go to court to be put in effect.
Yes, sir. Excellent. So, of course, once we have a will in place, people also fail to recognize that a will shall be probated. Probably the number one misconception. I hear all the time, Mark, I have a will, I'm covered.
No.
I tell them, hold on a minute. As long as you understand the ramifications of that, loss of time, money, and mandatory probate, are you sure you want to take that route? Everyone says, what do you mean? Or I never want that. And I say, well, hold on a minute. We better have a different discussion. So good point there. Yes, we have to be careful with that.
And people who need to, in my mind, I'm not from a legal opinion, but just from a business point of view, I can say should have a living trust or program put together ahead of time. If you have more than $167,000 of assets, not counting your life insurance, not counting your retirement funds, but of bank accounts and such, or real estate or other personal property, that has to be probated for full probate. Is one reason why you might do it, right? And if you have less than that, there's a streamlined process. But if you have more than that, unless you have a living trust, doesn't matter how good your will is, doesn't matter how clear it is, 1 heir, 2 heirs, 50 heirs, you're giving it all the way to charity. If you have more than that amount of money, you're going to go to probate court to effectuate the will, correct?
You sure are. Lots of facets to that. I don't want to really get into the weeds and bore people, but bottom line is people say a couple of things. I'm below the threshold, presumably. Ultimately, they think because they have a beneficiary form on file, the common rule there is that you will avoid probate with a beneficiary form, and you can have an indefinite number for that account. It can exceed 166,100 times. As long as there's a corresponding beneficiary form, it always avoids probate. Provided, the caveat there is that the intended recipient is alive. If the beneficiary, yes, sir, is unfortunately predeceased, the owner of the account, there's an automatic reversion back to the account of the decedent. And people say, wait a minute, we had a bank account, had a corresponding beneficiary form, no probate. Yes, provided. And then the other factor, which I hate, but happens frequently, is you'll find that the beneficiary form is misplaced. The financial institution lost it. They took Swatik's beneficiary form and put it into Swamper. And who knew? Bottom line is, it's not there, it can't be located, and the bank is unforgiving in that regard, and they don't have a choice. Typically, we have to go through probate. Right. So we have to be careful with these nuances.